So, good morning and welcome to this information session about EU citizens and the right to work. I'm delighted to welcome Dr. Olivia Vicol from the Work1 Centre, who are doing fantastic work with representing EU citizens' rights in employment areas. A little bit about the project that I have been running for the last 2 years but have now left. So I've moved into a different role in Citizens Advice Liverpool. My name is Cozy Derfel-Hill. I'm the partnership coordinator for the Access to Justice project and run the Access to Advice network. So the project I have just left is not a million miles away from that. It's the EUSS project where we helped EU citizens with their applications to the EU settlement scheme. What I've done essentially is move from one advice area to all advice areas, but certainly in the last 2 years with EU citizens, I have learned a lot about the intersectionality of how a newly brought in immigration status intersects with other areas of advice, such as employment law or benefits or even family law and so on and so forth. So a little introduction and rundown to the EU settlement scheme. The EU settlement scheme became necessary because of the UK's departure from the European Union. During the UK's membership of the EU, of course, all EU citizens could exercise the treaty right to free movement and could live freely and work and access services in all EU countries. This treaty right, this law no longer applies in the UK. We had a transition period that has now ended. We had a grace period during which people could apply to the EU settlement scheme, and that has now ended as well on the 30th of June. Okay, welcome to the session, Matt. Having completed this process of Brexit, EU citizens are now subject to UK immigration rules. There is no more free movement in the UK. And the question, of course, is how do you distinguish people who now arrive from the EU from people such as myself who've lived here for many years? So that's why the EU settlement scheme became necessary, to give an immigration status under UK law to people who've been here for a long time. Now, the application is done using an app on a mobile phone to scan an EU passport. And most EU citizens don't have one of these. You could also scan a biometric residence card. I have one because I've been here for so very, very long. Anybody who's lived in the UK since before 1989 can apply under the Windrush scheme, and that gives you a card, a physical document to prove your status. However, anybody who's been here less than 30 years will only get a digital status, so they have to check their status and their rights through a website, and that's what we will look at in more detail today. So having started the application with the mobile phone app to scan the passport, one then moves onto the website and completes the application on the website. The applicant has to prove that they have been resident in the UK. They also have to prove or they have to declare any criminal convictions, as those might prevent them from being granted the status. And obviously they have to prove their identity to show that they are eligible to apply under the scheme, as only EU citizens are eligible and British citizens are not. And also people who are dual British and another nationality are not eligible. So application completed, people can get one of two statuses. There is pre-settled status for those who have been resident in the UK for less than 5 years. This is to allow them to build up the length of residence required to then get settled status, which is for people who have been here for more than 5 years. This is also indefinite leave to remain. It is the same status. Indefinite leave to remain is just a more old-fashioned word for it, and the word that's used in the legal text, in the legislation. Now, obviously, the grace period has ended on the 30th of June. Olivia and I were just talking about what an interesting day that was, because a lot of people suddenly realized in the last couple of days before the deadline that maybe they need to do this application, or suddenly found problems. It was certainly interesting. In the month of June alone, the Home Office received over 400,000 applications. I dread to think how many it would have been just in the last day. Certainly a lot. There were big waiting times as well. Those applications were all considered in-time applications. As of the 1st of July, people can still apply, but it will be considered a late application, and the Home Office will only accept late applications under certain circumstances. So they have published, back in April, they published reasonable grounds for accepting late applications. And these are quite pragmatic for most people who genuinely didn't know about the scheme, aren't digitally literate, didn't have access to their passport, or for children where the adults around them failed to make the application on their behalf. Those applications will be accepted, and the EUSS project at Citizens Advice Liverpool will continue to help people with making these applications. We've actually increased the number of caseworkers that we have. So we've actually increased our capacity for the last 3 months of our funded project, and beyond that we will still have legacy volunteers who will continue to make applications. So yeah, we are continuing unabated. The contact details for the EUSS project at Citizens Advice are already in the chat. They are euss@caliverpool.org.uk, or the phone number 0151 522 1725. So that's that about the EUSS project. Now, when people have a status under the EU settlement scheme, they will have to check to prove their right to work to prospective and future employers. In the past, again, it was just done with a passport, but no longer. You now have to do it using a website. And to tell us more about this and about the issues that this presents in the workplace, Olivia is joining us today. So a very heartfelt welcome, and thank you for joining us. I'm going to hand over to you now, Olivia.
Fantastic. Thank you for having me, Kazi. And thank you everyone else for expressing interest in attending. So my name is Olivia. I'm an anthropologist by training, also a migrant myself. So this is something I care about very deeply. So that's why I'm really thrilled that you're here with me sharing this interest. I'm now going to share my screen. Okay, let me first tell you a little bit about what I do. So I'm CEO of the Work1 Center. We're a small charity founded by migrants and for migrants. We care very deeply about employment justice. We have a very multilingual team of advisors who work Monday to Saturday, helping people affirm their rights in the UK as migrant workers. Sometimes we spend our days helping people recover unpaid wages. Sometimes we help them challenge unfair dismissals, including because they were pregnant, or more recently, because they weren't able, or the employer wasn't able to check their immigration status in the UK. So we feel very deeply invested in this, and we care a lot about sharing what we know, and if we can, making some light of the situation that can sometimes be very confusing. So today I'm going to talk to you about conducting right to work checks for EU nationals, and with respect for the law and for people. In summary, we're going to cover 5 things. We're going to look at the legal context, then we're going to look at what this right to work check looks like in practice, what are the tripwires, take any common questions and misconceptions about the practical context. Then we're going to revise some take-home points and very briefly look at the new visa system that applies for EU nationals who, and actually all other migrants who arrive in the UK from the 1st of January this year. Then we're going to take your questions. Okay, I would like the set of scales to sink in a little bit when we talk about the legal context, because if there's one big take-home point I have for you, is that this is all about proportion and balance, and that as employers, we have a duty to immigration law on one hand, but we also have an equal duty to the Equalities Act and to employment law. So it's very important that we do both of these duties. We carry them both with dignity and respect, and that we don't let the attention and hype around the new immigration checks chip away at our other duties towards the Equalities Act. So as I mentioned, I'm an anthropologist by training, and I really love a good timeline. I think it's very important to historicize some of the things that we now take for granted. And that's where I'd like to begin by telling you that immigration checks, these things that we now talk about almost every day, they have a history themselves. I think it's very important for you to know that. So in 1996, we had the first Asylum and Immigration Act that criminalized employing a person who does not have permission to live in the UK. That was the beginning, but prosecution in practice was minimal. So we had the legal context, we just didn't quite have the practical context yet. This started changing 10 years later with the Immigration, Asylum and Nationality Act that basically introduced new civil penalties for employers, and it amended criminal offences for not conducting right-to-work checks. That's when fines began, and that's when the culture started shifting around employers. This shift was particularly exacerbated around 2014 when the fines for employing an undocumented worker increased as well. So levels of 5,000 to up to 20,000 pounds per worker. Now, workplace culture started shifting, and because when conducting an immigration check, you effectively have to find some kind of proof of someone's right to be in the country. That's what revealed the whole scandal of Windrush. It revealed that thousands of people had been living in the UK, forming families, being in the country for decades, but they didn't have that proof. Also because the UK, interestingly, doesn't have national identity cards, for instance, right? It has quite a liberal culture around citizenship and residence, at least up to that point. That's when Windrush came to light, because there's so much focus on employers conducting right-to-work checks and seeing proof. Now, all of this picked up new pace, and this is the Immigration Act that creates the context we operate in today, primarily. The Immigration Act from 2016, you might remember that was the time when Theresa May was Home Secretary. That's when the discourse around the hostile environment began. What that act effectively did was make prosecution easier. So employers could be prosecuted if they knew or if they had reason to believe that they were employing an undocumented worker. So it's fair to say that this is probably when everyone started caring very deeply about how they conduct immigration checks. And that's probably also when a certain culture of fear and reverence to the Home Office began. But as I mentioned, this is always about a balance, and I would like us to remember that, excuse me, as employers, we have a joint duty towards immigration and towards the Equalities Act. To some of you, this may be familiar, but I think it's important enough to warrant revisiting. So the Immigration Act from 2020 effectively protects people against discrimination, harassment, or victimization in the use of private and public services, but also in employment. And this, very importantly, includes recruitment. Some of the common queries we get at the Work Rights Centre are in fact around people who are discriminated against at the point of recruitment. And I'll tell you about this in a minute. Now, the Act protects 9 characteristics, so-called 9 protected characteristics. You may remember that these are age, disability, gender reassignment, marriage and civil partnership, but also race. And I'm highlighting race here because it's under the definition of race that nationality, ethnicity, and color become important. So if you take an action that discriminates against a person of a particular nationality, that matters deeply because nationality is included under the protected characteristic of race. Now, discrimination can take many forms, and it's really important to get what this looks like in practice. So on one hand, we have direct discrimination, which means treating a person less favorably because of their race or nationality. So for instance, in practice, if you put out an advert that rejects everyone who doesn't have British or EU nationality, that is effectively discriminating directly against people from the rest of the world. But discrimination can also be indirect. And this occurs where a provision, an action you take as an employer, puts persons of a particular racial or national group at a disadvantage. So this is something we've seen in practice quite a lot, and even among highly reputable, well-resourced employers. So for instance, if you require settled status in your job adverts, that is effectively discriminating indirectly against some migrants, because not everyone will have been resident in the UK for long enough for the 5 years it takes to have settled status. Some may have pre-settled status or other forms of leave in the UK. So it's important to remember both of them. Now, bringing together your joint duties towards the Immigration Act and towards equalities, there are a few things that I think you need to do as employers. The first is to check the right to work for anyone who is under a contract of employment, service, or apprenticeship, whether the contract is expressed or implied, in other words, verbal, and whether that relationship is formal or informal. So regardless of the status of the worker, they could be permanent or casual, fixed-term contract employees, they could be actually employees or self-employed, you have a duty to conduct that right to work check. Now, you also have to take responsibility for the check. And I'm quoting here from the Home Office Guide for Employers. The check must be carried out by the employer who the contract of employment is with. You will not establish a so-called statutory excuse if the check is performed by a third party, such as a recruitment agency or a consultant or advisor you hire. This doesn't mean that you can't delegate these duties, but ultimately you have the legal responsibility as the main employer who signs the contract. And also the duty doesn't apply to the particular HR member of staff or the line manager, it applies to the employer, the company. But you also have a duty, as I mentioned earlier, to not discriminate. So you can't simply check the status of people who appear to be migrants because of how they sound or because of how they look or because of what you might know about them. If you do that, you could be breaking the law. And I'd like you to remember, let this sink in, that there are serious consequences to an excess of zeal in immigration checks that ends up being discriminatory. So again, this is taken from the Home Office Guide for Employers. Anyone who believes that they have been discriminated against, and here I'm talking about members of staff, if they believe they've been discriminated against directly or indirectly by you, the employer, because of a protected characteristic such as nationality, they may bring a complaint before an employment tribunal. If the claim is upheld, the tribunal will normally order you, the employer, to pay the compensation for which there is no upper limit. And you can read more about this by going straight to the source, which is the Home Office Guide to Employers. Okay, now this is a brief overview of the legal context with the immigration law on one side and the Equalities Act on the other, and you having to strike the balance. But what does this look like in practice? Let's start with another beautiful timeline, revising some of what Cosima said at the beginning. Brexit feels like it's been happening for many years, so it's really important to get the particular dates that actually shift practice, because there's one thing to talk about Brexit for since the referendum, and there's another thing to act upon it. So you might remember that the UK officially left the European Union on the 31st of January 2020. That was the moment when EU nationals were reminded that they have to apply for the EU settlement scheme to secure the rights they had under free movement. But notably, even though the UK left the EU at that date in 2020, free movement was retained for another 11 months during a so-called transitional period. So what this meant is that EU nationals could continue to come to the UK under the same conditions as before. Now, free movement actually ended 11 months later on the 31st of December 2020. So that date is very significant because it was the last date when EU migrants could arrive under EU freedom of movement rules and qualify for the EU settlement scheme. New entrants arriving from the 1st of January, even a few hours or a day later, they needed a visa to work. So that's why it matters. Now, We had another 6 months when EU nationals were strongly encouraged to and reminded to make their applications to the EU settlement scheme. The scheme finally closed on the 30th of June 2021. Now, what the Home Office acknowledges is that late applications are likely to happen and some will be accepted, but it's very important to remember that at this stage, after the deadline, the Home Office has discretion over the applications that it will consider and warrant. At the moment, the guidance to caseworkers and to civil society at large is that they will take a flexible and pragmatic approach. And what that means is that they will be looking for reasons to grant rather than to reject applications. But of course, we have to wait and see how that happens. And there's always that element of risk, effectively, in the sense that they have discretion. Now, between the 31st of December and the 30th of June, those 6 months were called the so-called grace period, where the Home Office told employers, we recognize that there are thousands of people who are still making their application for the EUSS, and that is why we are going to equate immigration checks with just looking at someone's passport or ID. So during that grace period, if you're hiring someone new, all you had to see was their passport or ID. And also, very notably, you don't have to conduct retrospective immigration checks. So even from the 1st of July, you don't have to conduct retrospective immigration checks for people who you hired before July, right? However, new checks begin from July for new workers. Just a few things about the EUSS, because this is effectively the basis on which you will conduct the checks. One very common misconception we heard about at the Work Rights Center was, who is the EUSS for? And in summary, it's open to EU nationals and their family members. So please remember that just because someone doesn't have a passport or an ID issued by an EU member state, it does not mean they don't have status under the EUSS. They might be the partner or the child or the dependent parent of an EU national and still qualify for the EUSS and still prove their status to you, the employer, in the same way. So don't think that because their passport is different, they're lying when they say that they have EUSS. The second thing to remember is that this is a digital first process. The check is carried out online, and I'm going to show you in a minute exactly how. You'll need a few things from your members of staff. You will need their date of birth, the so-called share code, which is something they issue online by logging into the portal. And also you'll need their proof of ID, which during COVID could be online as well. I think the guidance might change around that, and you might actually have to see a physical proof of their passport or national ID. Now, the third and very common misconception around the EUSS, there is no physical proof of status. The only people who hold a card are, there's something that they can actually show you and then you can hold. There will be non-EU nationals who obtain the EUSS as family members. They will be the only ones who hold a biometric residence card. However, even they will also prove their status to you using a share code. And it's through that digital process that you effectively create a record of checking someone's right to work. Now, the final thing, and again, we have to let this really sink in, is that there have been more than 5 million, I think almost 6 million applications made so far, but the backlog is hugely significant for many reasons. A lot of people didn't know about the scheme. A lot of people were hoping that they could wait until the end to renew their passports and then not have to go through the more complex application with an expired passport. For a variety of reasons, the backlog is huge. Thousands of applications are still waiting on a decision from the Home Office. So I would like you to remember that just because someone doesn't have status yet, it doesn't mean that they don't have a right to work. They have that right to work, and you as an employer can check it using the employer checking service and effectively using the certificate of application. Let's see how this actually happens in practice. I'm going to take a step back and mute myself, and I'm going to show you two very short videos. They're very step-by-step. I think it's important for you to see what the processes look like on the worker side, because it's workers who have to issue a share code, and then in a minute on the employer side, because it's employers who have to check that share code. So I'm going to mute myself and let us all watch these very short videos.
Because of Brexit, all EU nationals will have to prove their right to live in the UK. This is a guide to how to do it if you have settled or pre-settled status. The whole process happens online. Open a web browser and type in Prove Settled Status. Look for the official government page. You can spot it from the page address, gov.uk, and it should be one of the first results you come across. Once you're on the page, it's a step-by-step process, so pay attention. First, add the details of the ID document you used to apply for settled status. Find it and type in the serial number. Then just add your date of birth. In the next step, you'll receive an authentication code using the phone number or the email address you used to apply for settled status. Let's say this time that you get it sent to your phone. Now you've authenticated, but you still have a few more steps to take. So scroll down to the option Prove Your Status to Someone. Select who you want to show your status to. Let's say it's your employer. Now you can preview exactly what your employer will be able to see, which is your name, picture, and right to work. But to enable them to actually see it, you need to give them a share code. Your employer will be able to use this code, together with your date of birth, to check your right to work in the UK. You can print this page and send it to them, or you can send them an automated email. Your share code is valid for a limited time period. You will have to repeat the process anytime you take up a new job or access a new service. But there's help available.
Okay, so I wanted you to see that because I think it's very important for employers to understand what process workers have to go through. I think it's also important to acknowledge that you don't have to be very digitally literate to be a good carer for someone or a good cleaner to do a fantastic job in the service industry. But suddenly, you have to be digitally literate to prove your right to work. So I wanted to show you the process, to draw your attention particularly to the fact that it's likely to trip some people. So remember that it involves this two-factor authentication process. So you have to put in your passport serial number, but you also have to put in a code that the Home Office then sends you on your phone number or email address. Now, imagine that a lot of people have applied to this scheme years ago. Some of them applied with help from a friend or from an advisor or from someone they paid, who may have made some mistakes and used their phone number instead of the actual applicant's phone number. Now, applicants have to go through a little nightmare to actually have these details updated by calling the EU Settlement Resolution Center, by effectively logging into this portal, right? They have to do it. So please be patient with them. That's why I wanted you to see it. Please use this as a resource with your staff if you think it will help. It has subtitles in 13 languages, and we can add more if that's useful. But the bottom line is please be patient and use your power and your kindness to guide people through this, because this is new for everybody. Now, let's look at what you, the employer, will have to do with the share code. So imagine that you have it already.
Because of Brexit, hiring people with status under the EU settlement scheme will require a new right to work check. This is a guide on how to do it with respect for the law and for staff. As an employer, the first thing to remember is that the EU settlement scheme applies to a whole range of people. This includes EU citizens with IDs issued by an EU country, but also their family members, whose passports may be issued by a country anywhere in the world. Here's how you conduct the right to work checks. Open a web browser and look up Check Right to Work. From the government page, choose the option to check the applicant's right to work online. Then it's a simple step-by-step process. First, enter the applicant's share code. We've explained how they can generate it in a different video. Then enter their date of birth. You will see a confirmation of their name and right to work. Check that the picture matches the applicant, then file a copy of the online confirmation and store it safely. You will need it for the duration of their employment and 2 years later. It's important to remember that some people may not have received a decision on their EUSS application yet at the time that they apply for a job. This does not mean that they don't have a right to work, and you can still check it by using the employer checking service. Before you start, you'll need their date of birth, nationality, and Home Office reference number, which can be found in their certificate of application. When it comes to immigration, there's a lot at stake, but remember that as an employer, you have to abide by the laws of immigration, employment, and equality. Imposing excessive requirements that single out or penalise EU nationals who work or who want to work for you is a form of discrimination that carries serious consequences. So stay informed.
Okay. Again, this is available on YouTube, and you can get back to it at any point. But the main point is, it's a digital process. There's a separate process for people who have an outcome on their application and can issue a share code. And then on the other hand, for people who are stuck in that backlog, for the thousands of people stuck in the backlog who won't have an outcome but can give you a certificate of application. You can use that. There's a separate process via the employer checking service.
Because of Brexit.
Now, I'd like to address one of the two common questions we received at the Work Right Centre over the past couple of weeks. One of them is, assuming that you have staff employed before the 30th of June, right? So they started working with you before the EUSS ended, but you find out that some of them lack proof of their right to work. What do you do? The bottom line is, be patient. Don't assume that you can dismiss them. So I'm quoting this from the Home Office Guide to Employers again, because I'd like you to have the certainty that this is what the Home Office says. It's not my interpretation. So as a transitional measure to provide additional flexibility, in circumstances where you identify that an EEA citizen in your workforce has not applied to the EUSS, you do not need to cease employment at the time you identify that, okay? In these circumstances, there's a process. So it starts with, number one, advise the individual that they have to make an application within the EUSS. And the Home Office gives you 28 days to do that, okay? When they make the application, ask them to provide you with confirmation that they have made their application. And confirmation can take several forms. This can be a certificate of application. It can be an email or letter if they submitted a paper application. Now, some people might submit a paper application if, for instance, their passport expired. And I'd like you to remember that dozens of EU consulates are now struggling with a huge demand of passport inquiries because people haven't been able to travel back to their home countries. So there's a huge number of people who will likely have to apply using a paper application or have applied with a paper application. These take longer to process. So don't assume that just because they don't have something digital, they haven't applied and they're lying to you. Now, once you have confirmation that they have made a late EUSS application, you have to request a right to work check from the Home Office employer checking service, and that is the link you can access. The Home Office will then reply to your request. It will give you an intermediary form of proof. It's not proof per se, it's basically saying, regardless of the outcome of the application, you, the employer, have done your job. So you won't be in any kind of trouble, even if it later turns out that this person's application is rejected. And then you have to conduct the other right to work check once the person actually gets their status. And please do go to the source and read this in the Home Office Guide to Employers. Now, the other common question is, what happens if someone lacks proof of right to work, but you're looking to employ them now from the 1st of July? The short answer to that is, well, you can't really employ them. You can't employ them. So for those who are employed on or after the 1st of July, you must perform the appropriate right to work checks prior to employment. So in summary, there's a few take-home points here. I'd like you to remember the following. The first is that you really don't need to conduct retrospective checks. If you do, you have to do it for all employees of all nationalities in a way that's not discriminatory. So you can't say, oh, you look Romanian and you sound foreign and you look foreign, therefore I'm going to select you and ask you to prove your right to work. It can't be like that. You have to find, if you feel the need, even though the Home Office doesn't ask you to, if you feel the need to do these checks, you really have to think about how to do it in a way that's not discriminatory. Now, not every EUSS holder is an EU national. Right to work checks happen online and proof is digital. And again, you can check the right to work of an EUSS applicant, even if a decision is pending, by using the employer checking service. You can also support your staff, those who you employed before the 30th of June, in making an application, even after the deadline. So remember that at the moment, the Home Office stance is we will look for reasons to grant, not to reject applications, even late applications. But you cannot hire new staff from the 1st of July unless they can prove to you that they have a right to work. Now, I also wanted to take the liberty to suggest some good practice, because I think as employers you have a lot of power, right? And you can wield that power wisely. My first recommendation here would be to be patient and to support your staff if they need help in issuing a share code digitally. It's a complex process. It's new for everybody. So please be there for them if they need time to find documents from the Home Office. My second recommendation is to be proportionate. Remember that you have joint duties towards immigration and equalities law. And to stay informed. This is a rapidly changing area of advice. Please go to the source, read the Home Office employer guide. It's not the best prose, but it is very informative and practical. So please do go to the original source. Now, very, very briefly, the practical context for EU migrants who arrived after the 1st of December 2020, sorry, 1st of January 2021, so after freedom of movement ended. In summary, they will need a visa through the points-based system. So the points-based system applies to everyone arriving after the 1st of January. It includes EU nationals and non-EU nationals. They'll need a visa first before they enter the UK, but visas can be renewed or extended in the UK. There are many types of visas out there, including a frontier worker permit, which applies to someone who lives in another country but holds UK-based employment. Student visas, of course, visas for intra-company transfers, or temporary work, or for skilled work, and this is what we'll focus on today. Now, the skilled worker would basically replace the Tier 2 visa and is valid for up to 5 years. Eligible jobs must meet certain criteria. First of all, they must be advertised by an employer approved by the Home Office. So you need to be accredited by the Home Office, and this can take up to 8 weeks. The job itself has to be on a list of eligible occupations. You can look this up. I'm providing the resources at the end using a job code. It's also important to remember that the government is effectively trying to restrict immigration at the low-paid end of the labour market. So the job has to be paid at either 25,000 a year or just over £10 an hour, or the going rate, whatever's highest. There's only exceptions for a number of shortage occupations or for applicants who are highly qualified at PhD level. Now, there's also criteria that apply to eligible workers. First, they must prove knowledge of English. They must obtain a certificate of sponsorship from an employer. They must renew the visa upon changing employers or before it expires. So this gives them a lot less freedom. It basically ties them to one employer. And yeah, I realize it's a lot to take on. So I wanted to end with a number of resources for you to review and revisit in your own time. As ever, the Home Office Guide to Employers, and the Code of Practice for basically avoiding unlawful discrimination. Also, any questions you have, you can address them to the Home Office Employer Inquiry Helpline. Please do call them and check before you take actions that could change someone's life. And also at the Work Right Center, we are here for you for any further questions or training. And with that, I'm going to move us into the Q&A session. And thank you all very much for your attention.